Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
This is Serious Privacy by TrustArc. Here are your hosts, Paul Breitbart and Kay Royal.
So my name is Paul Breitbart.
And I'm Kay Royal, and welcome to Serious Privacy. So this is another week of privacy with Paul and I, and our unexpected question is, what's the most expensive thing you're wearing right now?
I guess it's my watch.
Your answer is about as exciting as mine. Mine's
I think it is my Apple Watch. Yeah, it's not too excited, but that's about what we have. So yeah.
Yeah, and mine is one of my wedding rings.
Okay.
So the one I'm wearing now is the one I got on our 15th anniversary, and it is Levian chocolate diamonds, and I love it. So yeah, okay, there we go.
No, I think I need to revisit when you talk about rings. I don't even notice most of the time that I'm wearing a ring anymore, but I am wearing a signet ring, and I think that's probably more expensive than my watch. So, yeah.
Ooh, show it closer in the video so I can see. Oh, that's gorgeous. I love that.
So, yeah, that is the coat of arms of my great-grandmother's family.
Wow. Okay. But yeah, I usually have on my Samsung watch, and I keep forgetting to charge it. But yeah, okay. So what do you want to talk about this week, Paul? We've had quite a bit going on. We just published your episode with the wonderful speakers you got at the IAPP Intensive in the Netherlands at The Hague. It was awesome. It's a very long episode. We always apologize to our listeners because we know y'all want like 30-minute episodes, but these speakers were really good. Paul got some really good quick interviews with people.
Oh, but and otherwise people walk the dog twice a day, so then they can do half the episode in the first round and half the episode in the other round. Or two commutes, one into work and one back home. Something like that.
Well, that is true. We're a weekly podcast, so you can break it into two episodes. We have that. But there is a lot going on for this week. A lot. So here in the United States, and I'm sure you've kept up with this, we've had hearings on the proposed, American Data Privacy and Protection Act?
Yeah, ADPPA.
Yeah, ADPPA. Yeah, not a very sexy acronym. If y'all can tell us a way to get away from the P's and the D's and the A's, let us know. I think we could replace the A with an L or an R.
For the R for Republican or
regulation, GDPR.
Oh, that A. I was thinking about the A for American.
I was thinking ACT.
How are you going to do away with the A for American? That will be a difficult one.
Oh, United Statesans.
And how will you get away from the P for privacy or
D for data or
protection? Yeah, I mean, there was only so many acronyms that you can build.
Your information security, not the quite same meaning as data protection.
No, that's something completely different.
Oh, but that is interesting.
We'll keep it to ADPPA.
Yeah, ADPPA. But it is interesting because it's not perfect. I mean, you and I have discussed how long is it going to take for the U.S. to pass a federal omnibus privacy law. For those of you who may not know, omnibus means that it applies in general. It's not restricted to a particular sector or a particular type of data. It's a general privacy law. So we've been talking about how long will it take the U.S. to pass one, and we didn't think it'd be anytime soon. But it is interesting looking at the ADPPA, whatever the heck they're going to call it, and who they had testifying to, testifying, providing their opinion at the hearing, and people could watch the hearings live. I got to catch quite a bit of it. But the people presenting at the hearing are, let me see if I can pull up who all presented at this hearing.
Well, in any case, I saw EPIC, I saw FPF, I saw the former FTC chair, Maureen Olhausen.
Yep. The Lawyers Committee for Civil Rights Under Law with the Digital Justice Initiative, Common Sense Media, which I really like. One I didn't expect, the Information Technology Industry Council.
Okay.
The ACT, the App Association. So the testing that we do here. The National Association of Convenience Stores, which I have read a little bit about the Retail Association's opposition to the law. And the 21st Century Privacy Coalition, which was with Maureen. And so we'll give you the link of where, who was able to speak. And then they have posted their testimony, as well as I believe there's a YouTube recording of the hearing. So very interesting. What wasn't in the hearing was people like us. People who actually are engaged in the implementation of privacy.
No, I saw that too. And I saw also some people on Twitter responding to that part, that was lacking and that should be part of a next hearing. Although, of course, the civil society groups would have some experience also on this part. So it is
absolutely.
It is not just advocating that there should be high standards, but also how to operationalize them. But I think, indeed, that would be welcome.
A lot of them come from that audience, so it helps with there. But I mean, I have to admit, if they are going to take testimony from people in the industry that are implementing privacy, running privacy officers, that here in the U.S. is not as common to have a DPO unless you have global operations, but the chief privacy officers, whether they have that title or not, the highest person implementing privacy in your organization, which, by the way, they should all carry the title CPO if they're the top person in your organization managing privacy. But hey, let's move on. So who would you expect would testify? It'd be the big companies. It'd be Intel. It'd be Microsoft. It would be
Google, Facebook, Amazon, Apple, which is not necessarily a bad thing. I mean, if you have people like Jane Horvath or Julie Brill testifying on behalf of the DPO community or the CPO community on how to operationalize this, they have both been advocating for strong privacy legislation for a long time. That some of their lobby departments also give some counter arguments towards not too strict interpretation of the legislation.
Right.
I won't hold them accountable for that.
Right. And there are pros and cons to that. I mean, they have the industry moxie for people to listen to them, to have influence with the legislators. Whereas if I tried to testify on it, I would sway no one that would be listening. The only thing I'd be able to do is educate them as to what the differences are between implementing a privacy or managing a privacy program at a very large global organization versus 97% of the rest of us out there that are at medium and small businesses that don't have the resources or the policy impact that the larger companies do. But that's why there's a Fortune 100 and a Fortune 1000, and then there's the rest of us.
Mm-hmm. Yeah, and I mean, they should probably hear from all sizes and not just from big tech.
Right.
And maybe also hear from some of the government privacy and civil liberties officers who might also be working with this legislation, because I don't believe it is limited to the private sector. Or in any case, in my view, it shouldn't be limited to the private sector. Let's keep it at that. But if you also look at some of the responses that I saw from people following the hearings, I couldn't follow them because of, work.
Right.
And this is not my work anymore. But one of the things that I saw is that there are a lot of people who also said, well, this seems to be a really serious bipartisan affair. This is so not the representatives in the hearing catching each other off guards and stealing each other's topics and making sure that the other side looks bad, but actually picking up lines of questioning across the aisle, really working together to get more clarity on these issues, on things like, what does it mean to implement privacy, it did come up. What does it mean for individuals? What does it mean for companies? What does it mean for enforcement? What is privacy by design and how should it work? Should you have guidelines? Should you have maybe some implementing rules? Should it be fully free? So I was actually happy to read at least some of the comments on these hearings, that it seems to have been a pretty positive affair. And of course, the fact that the hearing came so quickly was already a very positive move.
Right.
So,
indicates they really want to move on this pretty quickly. So I hope that momentum stays. Now, there are some criticisms that, there are people that have been supporting privacy laws for quite some time, and they're not signatories to this.
yeah.
Like Cantwell, who has been supporting privacy laws and has had her own drafts up for a while. Hers are still active and live, but we're not seeing any movement on them. So I do think that in order to fully succeed, I think they need to get her to sign on, or she's going to sign on. One of the two. She may not, and it may proceed without her. I mean, it's not the first time we've seen that happen too. But it is interesting that there are quite a few exemptions. There are exemptions that you would expect for existing federal laws, the GLBA, HIPAA, things like this. But it is also, you and I discussed this under one of the state laws. They exempted the entities subject to HIPAA. They did not limit it to the HIPAA-covered data, PHI. So this one does limit it to the data that is covered under those laws, and not necessarily the entities that are subject to the laws, because as you and I have discussed, entities that are subject to those laws manage much, much more data than just what's covered by those laws. The preemption, of course, they intend to preempt state laws that are contrary to them, but they also mentioned specifically that they would not preempt the Biometric Information Privacy and Act under Illinois, or the Genetic Information Privacy Act, the CPRA. So they're stating they don't intend to preempt them. And that was one of the most controversial topics in being able to pass a U.S. omnibus privacy law, was state preemption. The other was a private right of action. And there is a private right of action in here.
Yeah, albeit a fairly small one, right?
It doesn't take effect until 4 years after the law passes. I don't necessarily think it's small. They can bring civil actions in federal court. They can acquire or be awarded compensatory damages, injunctive relief, attorney's fees, and litigation costs. And I have seen that the industry is pretty up in arms that they do believe this right of action should be more limited, because they do, and perhaps rightly so, believe that class action lawyers are going to jump on this from the get-go. Now, if the plaintiff does request a monetary payment in writing, either before 60 days from the FTC receiving notice, or after they determine if they would seek civil action, then the person's request will be considered in bad faith and unlawful. So there are some limitations in here that would limit the actions of individuals, but the private right of action itself is actually, I don't think it's small.
Okay.
But maybe by European standards it is. But I mean, here we're all over the class action lawsuits. And I do carry some of that reservation myself. I mean, if class action lawyers are going to be all over this, is it really giving any power to the individuals to seek a private right of action? Or are we literally just looking at who the class action lawyers are going to be able to take on and stop the industry from doing actions based on a few large class actions, and then everybody else will walk the straight and narrow?
Well,
There's pros and cons.
Yeah, and class actions are still not a very big thing this side of the Atlantic. It's coming, and it's probably coming fast, but we'll see. We're still not the most litigious people on this planet, I guess.
Right. And I don't know that anybody can be more litigious than those of us on this side of the ocean.
Probably, yeah.
We like our litigation. And, it's interesting that I never really thought about this before, but bear with me here as I literally think out loud. Here in the U.S., we do prize individual rights, maybe not around privacy, but the individual right to be able to do things and to take action. And most times that culminates in business endeavors. You know, we're all about commerce and business and pulling yourself up by your bootstraps. That might translate over into how we approach things done wrong to us. We take it to court. We enforce our rights to be able to protect ourselves. And that probably translates just as easily over into privacy lawsuits.
Mm-hmm.
That Europe is about the individual's right of redress, in particular with the governments or companies. Our right to redress is we can sue them.
If there is a legal basis, if you have that private right of action included in the final text of this ADPPA.
ADPPA. Yes, exactly. And I don't know, maybe my epiphany has already hit many people decades ago. But, you know, I never really applied it to privacy when we're looking at that. But I do think it's interesting that they do have that ability to do so. And right now they can't because they have to be able to show harm. And there is limitations. You have to be able to have an alleged harm, I believe, of $1,000 or something like that. So it might be limited in your perspective there. I do believe that large data holders, and we're seeing that pretty consistent across privacy laws, that there is a difference between companies that manage a lot of data versus companies that don't. And so large data holders would have additional requirements such as doing the impact assessments, having annual certifications, reasonable internal controls, reporting structures that give some sort of independence in the decisions and overseeing the compliance. Data security, of course, is required. They are supporting a unified opt-out mechanism. So come hell or high water, we're going to have unified opt-out mechanisms recognized in some way, form, or matter. I think there is some things they don't have, which has come under scrutiny as well. That there are some exemptions for a lot of the industry sectors, which is surprising on some of them, like the broadband internet, things like that. There are some broad exemptions there. I don't believe that the criticisms of it, I don't believe are as significant as some of the industry associations that are issuing those criticisms would have us believe. But I'm just glad to see that on its face, the way it stands now, this is not a weak bill.
No, it is certainly not, and that was also not what I was trying to say here. No, it is certainly not a weak bill. I think it is a serious bill, and it's probably the closest that we've ever gotten to a serious discussion about data protection law at an omnibus level in the United States.
Yeah. I agree. And I wasn't saying that you were saying it was weak. Sorry, I was thinking of all the conversations that we've had before, that my fear was that by the time the U.S. passes a federal privacy law, it's going to be so weak and watered down, it's going to be ineffective and it's not really going to accomplish much. So I was really glad to see that it is not as watered down as I was afraid it would be. Now, of course, we're not at the end. The lobbying and the compromises and the discussions that might occur, amendments in committee, different things like that. So it might be a different beast when it gets to the end, but I don't think so.
And that all needs to happen within how many weeks?
Not very many left. So, but they are moving fast. And that part I really appreciate. So they are moving fast. So there we go. So that's one of the things that we've got moving here, is that some of the others are not really that exciting. What have you got top of mind on your side of the pond?
So one of the things that's top of mind is that this week, actually Thursday, Friday, the EDPS is hosting a conference on the future of data protection. So while the US is discussing the first omnibus data protection bill that may actually become law, Europe is preparing for the successor of the GDPR.
Of course it is. Of course it is. But none of these things move quickly. I mean, frankly, I think it's interesting. The run up to the GDPR was how many years in the making?
The first discussions on what was called the future of privacy were probably started in 2007, 2008, concluded in 2009, with then the initial proposal in 2012 and adoption in 2016. So that took almost a decade. So if you want to talk about the successor of the GDPR and you fear that a similar time frame is required, then you probably need to start talking now if you want GDPR to be replaced somewhere in the 2030s.
Where, as opposed to the U.S., you can propose a bill over and over and over again. It doesn't mean the conversations for that bill are going to be the same or build on what the conversations were from the year before. So you probably won't hear the United States talking about, oh, well, we had 4 years of discussion before we did so-and-so. No, we tend to pass it, and then we defer enforcement, and then we pass a slew of amendments, and then we slide amendments into other bills for other things that might impact one thing of this one because someone had a particular itch that needed to be scratched. And
that's the difference between the legislative process on both sides of the Atlantic. But this event will actually be interesting. It is of course mainly aimed at the regulators and people really working on enforcement. So also the NGOs will be there. The civil society groups will be there. But if you look at the conference agenda, they will talk about what does it mean, effective enforcement? Can we work towards the golden standard? What can the GDPR learn from the rest of the world? How do we deal with complaints handling? How can we make enforcement easier so that it doesn't take as long as it does today? But also, for example, talking about digital sovereignty. Talking about enforcement in the public sector, talking about privacy. Well, maybe at some point we'll see that new e-privacy regulation. And there are keynotes by the EDPS, of course, by Wojciech Wiewiórowski, also by several of the European commissioners, including the Commissioner for the Digital Economy, Digital Age, the Commissioner for Justice, the Commission for Fundamental Rights. So it's a very prestigious conference. What I do like is that they also have the one-stop shot of coffee as their coffee break. So I think it will be a lot of fun to monitor part of this conference as well. I won't be attending, but I'm sure that we'll get feedback from the event via the social media and probably also by some clips.
Now, will it have live viewing of the conference? I don't imagine this conference is like our Senate hearing where you can actually view live. But I mean, are the programming or the conversations available live for anyone to participate virtually or to watch?
I think you can actually watch most of it live online, yes. Okay. So that will be possible. And then also this week, because everybody is in Brussels anyway for the EDPS conference, there is
everybody who is somebody, which is not me.
No, well, I mean, I'm also not there, but there is also the plenary session of the European Data Protection Board. And they also have some interesting topics on the agenda, so we can look forward to the press release in the coming days that should be available by the time the podcast is live. But for example, they will be talking about studies on data protection laws in third countries, which is run by the Borders, Travel and Law Enforcement subgroup, which is also focused on government surveillance. So they will be looking at making maybe some standardized assessments. There will be discussion on the Transatlantic Data Privacy Framework, although that is just information from the European Commission. Yeah, the thingy. It still seems that also the European Data Protection Board has not yet received any draft language from the thingy. Also hearing the Dutch DPA at the Data Protection Intensive in The Hague last week, very much under the impression that there are no final texts on the table yet. And with Chris Hoff, of course, now having joined Microsoft and having left the Department of Commerce, I am fearful that there may be some further delays and that the political agreement was really only a political agreement without any solid foundation yet.
It was an agreement in principle.
Yeah, but without underlying documentation, it seems.
Yeah.
There will be a request
My
for
optimism is taking a little bit of a hit on that one.
Mm-hmm. Yeah.
But
There
I
is
almost did come up with a backronym for thingy. Start with the, TH, international, IN, G, governance, and then if you end in IE, of information enterprise. The International Governments of Information Enterprise. Maybe it should be efforts, information efforts. Okay. Sorry, back to our regularly scheduled programming. It's weird how the directions my brain goes, but hey.
Yeah, your brain is weird, but I think our listeners know that by now.
It comes with that whole thing of I was surprised to learn that not everybody has an internal dialogue running. And when I put out my informal poll on LinkedIn, and I tried not to influence it one way or the other, but anybody who knows me knows what my brain has, asking, are there people that have internal dialogues running? Are there people who don't have internal dialogues running? And there was a lot of people. It was not quite 50-50. It was more like 60-40. 40% do not have an internal dialogue running. I don't know how that works. But the people that don't have it running don't know how we would have an internal dialogue running. How would that work? So
you do know you are now having your internal dialogue running out loud, right?
Yeah, I kind of realized that. We're just going to keep going. What else you got coming up? I looked up privacy news that I may have missed.
Yeah, well, there are some other things coming up that I'm really curious about, and that is, for example, a discussion also within the European Data Protection Board on data transfers to the Russian Federation. It seems to be an odd time to start discussing this, but maybe this will be a discussion for a non-adequacy decision for the first time. So that is something that I am very curious about.
Almost as in a repercussion or consequence.
Exactly.
But where is Ukraine in joining the European Union?
That should be discussed by the end of this week or early next week at the European Council level. The European Commission is expected to make recommendations to the Council of Ministers and the European Parliament on Friday, so that would be June 17, for the candidate status for Ukraine, Moldova, and Georgia, the country that is, not the US state.
Yep.
And it is expected that Ukraine and Moldova will get a positive recommendation from the European Commission, Georgia not yet, but that the member states do not agree yet to award any candidate status to any of these countries. But yeah, I think it's an odd timing to start discussing Russia data transfers, but there may be a very good reason for that. Another thing to look out for is that we have our third dispute resolution mechanism that has now been announced. And this time, there are member states that disagree with the CNIL, with the French Data Protection Authority.
Go figure.
Indeed, go figure. That was the topic for discussion today. Apparently, there is a dispute on the draft decision of the French Supervisory Authority in light of an investigation into the Accor hotel chain, which is Sofitel, Novotel, Mercure, those kind of hotels. I'm not sure yet what the decision is about, what kind of data processing is involved here, but apparently the European data protection authorities do not agree with each other on the outcome or on the sanction or on the scope of the investigation. That we don't know yet, but it was the topic of discussion today. So expect to hear something about this just after the European summer break.
And give me the lowdown there. So the CNIL is kind of stepping out there. They usually do. You're usually known for the Germans and the French to step out and be loud and proud. But the CNIL seems to be unusually loud.
They are
right now.
They are, and they really want to make a point of imposing serious sanctions, also making sure that people realize that playtime with GDPR is over. When looking at what might be the topic of the investigation here, it could be related to a very big data breach that Accor has had some time ago, which would make sense if that is the topic of investigation.
Okay.
But yeah, there we will need to see. It will take, as said, it will take some time before we get any public information on this, because with a dispute resolution, then Although maybe it looks like there might be a decision taken actually
Okay.
maybe this week.
Okay, we can follow up on that.
We'll need to follow up on that as soon as more information becomes available, also in the press release of the ADPPA after the meeting has concluded.
So more news to come on that one. And then as we are hitting time, I don't know, we talked about it a little bit about here in the U.S., how there is a renewed focus on ed tech for kids and how that has become an issue. Now at the IAPP Global Summit, every single regulator, when asked what are your priorities for the next 3 to 5 years, they included children's online safety as one of their priorities. So we know that's a focus, but here it's been a big topic that the FTC plans to focus on this. They issued a policy paper. We talked about it on prior one, but Minnesota has now passed a bill out of the House and the Senate. It's going to the governor on children's privacy for ed tech. And so what ed tech companies will have to do. In particular, working with schools. I mean, there's some debate is this specifically schools with ed tech working with it, or is this ed tech for children altogether? And as you can imagine, it's a topic for me to focus on. But it was interesting. I think I saw one of our friends posting that today on LinkedIn, there being a story about Lenovo and some of the monitoring software that is built into the computers that the schools are using and how that software is monitoring and tracking children. And that seems to be the overwhelming concern, is the monitoring and surveillance of children and their online activities. The computers all have cameras. Are those cameras turned on? We've had several scandals in the past of schools that were monitoring children remotely through their cameras without permission, different things like that. So I think this is interesting to see, maybe not a renewed focus, but a more in-depth focus on the privacy protections of children using technology in an education setting. And I think we're going to see more of that.
Absolutely. So yeah, lots happening, lots of small things, lots of big things, and we'll try to keep an eye on all the other things that will happen also outside of the US and the EU, which obviously are our core focus when we also need to do a lot of other work. Sometimes,
but we did just do a webinar on the PIPL, so I mean,
exactly. I mean, but this
trust me, we don't just focus on the US and the EU.
No, we don't. But in between all the other work, then sometimes there is only time to focus on Europe and the United States. So that's what we have today. Thank you for listening again to another episode of Serious Privacy. If you like the episodes, please rate and review us in your favorite podcast app or your favorite podcast platform. Reach out to us via seriousprivacy@trustarc.com if you have any questions or suggestions, via Twitter at @podcastprivacy, or look for Serious Privacy on LinkedIn. You'll find Kate on Twitter as Heart of Privacy and myself as Paul B. Until next week, goodbye.
Bye, y'all.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No. That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace, so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data, and get credible, cited answers based on NIMD research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows, to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore ARC at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.